On 4 April 2026, defendant Flory appeared in the courtroom of judge in the Huron County Circuit Court, Michigan for sentencing. Mr. Flory was facing multiple felony counts, including resisting and obstructing a police officer causing injury and indecent exposure. Additional charges are listed in the case docket. The legal framework here includes MCL 758-1D, MCL 753-35A, and Michigan Sentencing Guidelines MCL 7 and 77.1 SK. The court was deciding whether this case called for a prison sentence or a more rehabilitative alternative, such as probation with a boot camp component. That question mattered because the defense and the prosecution were making very different arguments about what the defendant's conduct meant, what the victim and officers experienced, and how the sentencing guidelines should be applied. In other words, this was not only a question of punishment, it was also a question of proportionality, public safety, and whether the defendant's substance use should affect the sentence.
Regretting walking out of that bathroom even for a second, knowing I was willing, I was totally by myself. I now realize even though they can walk, talk, and feed themselves, that does not mean they can be left alone. I have since learned from my mistakes and are now asking this.
Mr. Rukowski, anything you have for the people?
We believe the pre-sentence investigation is accurate, and
So that's the defense's position. Boot camp, probation. Discipline through structure, not prison walls. On paper, it sounds reasonable. Mr. Flory has no prior felony record, none. And kratom, the substance he used, is completely legal to buy and consume in Michigan. But here's where the prosecution pushes back hard. Because whatever the legal status of kratom may be, what happened at that campground that night was anything but legal. The prosecutor stands up and makes a comparison that is very hard to argue with.
Sustained severe burns to their face and deprived me to removal of tissue. I'm assuming to remove the damaged tissue based upon what these children went through. And, you know, maybe I'm old school, but our children, and actually that was my job as a parent. And it was awesome, frankly. You're spending time with your children, but you're watching everything they do, because whether you place them in the bathtub or if they're really young in one of those portable type of things that fold out, hold water, but you have to.
So what exactly is kratom? Kratom, spelled Kratom, is a plant native to Southeast Asia. Its leaves contain compounds that act on the same brain receptors as opioids. In small doses, it can act as a stimulant. In larger doses, it acts more like a sedative. It's been marketed as a natural alternative to painkillers, an herbal supplement, a way to manage withdrawal from harder drugs, and in most of the United States, including Michigan, it is completely unregulated. You can buy it online, in smoke shops and gas stations, no prescription, no age restriction in many places, no warning label required. But here's what the marketing doesn't tell you. At high doses, or in people with underlying substance use disorder, kratom can trigger aggression, paranoia, and erratic behavior that looks disturbingly similar to what was seen during the bath salts epidemic of the early 2010s. If you remember bath salts, you remember how bad it got. This judge remembers, and he is not going to stay quiet about it.
All the aunts and uncles were there, and then all of a sudden, they're all gone. It just came upon us. Oh my gosh, this is our responsibility now. And we had to be responsible. Were we perfect? No. Were you perfect in this case? No. But a message has to be sent that you understand that your children are the most important commodity in your life, above a significant other, above a parent, above a friend. Your children are everything. You die for your children, essentially. And you can look upon this case in a matter of ways. One, you could say, lock her up, throw away the key, you're a terrible parent. That's one way of looking at it. On the other side, you have a 21-year-old with no prior record who some people might say, the court's not saying this, but some people might say, you don't have business being a parent. But you are a parent, and you have to be responsible. And there's another side of it that, look, I'm not experienced. I don't know necessarily how to do this. They don't come with a manual. I did my best and I really screwed up. And there's no doubt about that. This is a tough case for the court because the court has to balance the interest of society, the interest of justice, tailoring a sentence.
That's what a sitting Michigan judge just called a substance that is legally for sale in his own county, right now, today. But even with that strong language, the judge has a job to do. And that job requires him to be fair. Because here's the legal reality. In Michigan, voluntary intoxication is not a defense to a crime. It doesn't matter if the substance was legal. If you choose to consume something and then commit a crime, you are responsible for that crime. But, and this is important, intoxication can be considered as a mitigating factor at sentencing. It can influence how long someone goes to prison, even if it can't keep them out of prison. So now the judge has to do something very rare. He has to think out loud and weigh both sides right in front of everyone.
Because in one alternative, if I just simply throw away the key and follow the guideline range of 9 months, Mr. Rooney's right. There won't be visitation with those children in the jail. That's an absolute unfit place for the child or children to be visiting their parent. But on the flip side, if the court just says, you know what, no harm, no foul, conviction enters, no jail time or minimal jail time, and then let the NA case address the matter moving forward. And frankly, I don't know what the status is of the NA case at this point. I'm not sure. And I don't want you to comment on it. But I know that I will be presiding over that case as well. And the number one concern of this court, and it has been for years and will continue to be, is these children. That's number one. Even on divorce cases, for instance, when parents are arguing and the court has to make a decision regarding custody, it's not based upon, well, we want to do what's best for the parents. It's best for the child's best interest. And that applies here as well. So with that long diatribe, it will be the sentence of this court. You'll be placed on a term of probation, not for 3 years.
You just watched a judge genuinely wrestle with a decision in real time. On one hand, a man with no felony record, a job, and a substance problem who used something legal and lost control. On the other hand, a deputy with a bloodied lip, families running in fear, a knife, a taser, and a campground that will never feel quite as safe again. Now comes the part where the law steps in and tries to give the judge some guidance. Michigan judges use what are called sentencing guidelines, a grid system that calculates a recommended prison range based on the severity of the crime and the defendant's prior record. These guidelines used to be mandatory in Michigan. A judge had to sentence within the range unless there were substantial and compelling reasons to go outside it. But in 2015, the Michigan Supreme Court ruled in People v. Lockridge that mandatory guidelines are unconstitutional. They became advisory, meaning the judge can consider them but doesn't have to follow them. And now, just days before this hearing, a brand new appellate decision has come down that makes things even more complicated. The judge is about to explain it, and you can hear the concern in his voice.
Not to engage in any assaultive, abusive, threatening, or intimidating behavior. Clearly, this was not assaultive, but this was abusive. In hindsight, I'm giving you some credit there. No verbal, written, electronic, or physical contact with anyone in the house within an MDOC facility, nor the same type of interaction with anyone that's engaged in the behavior that constitutes a violation of any criminal law of any unit of government. You may not use any object as a weapon. You cannot own, have under your control, area to control a weapon of any type. You must not even possess an imitation weapon. You can't be around anyone that possesses those items. You're to contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You are to complete and comply with all written and verbal orders of the agent, submit to a search of your person and property, including but not limited to your home, vehicle, or computer, without the need of a warrant if the agent has reasonable cause of items that violate the terms and conditions of your probation. Any arrest or police contact, loss of employment, or change of address must be reported to the agent within 24 hours. You are to notify the agent of any service of a personal protection order on you within 24 hours of service.
The guidelines say 14 to 29 months minimum. The judge could go as low as 12 months in county jail, essentially a slap on the wrist for what happened at that campground. Or he could go all the way to 29 months, the very top of the range. He has already told us what he thinks of Kratom. He has already acknowledged Flory's clean record. He has already heard both attorneys. Now, it's time. Watch how he builds to this sentence. Watch every word.
A minimum of 30 hours per week unless engaged in alternative programs approved by the agent. Crime victims assessment of $130, probation supervision fee of $30 per month regular, $60 electronic. Court costs of $200, payable at the rate of $10, we'll make that $5 a month. Fine of $200, payable at the rate of $5 a month. Court's waiving attorney fees. $68 in state costs will be ordered. The probation office is authorized and empowered under statute to effect your apprehension, detention, and confinement of up to 72 hours on reasonable cause you have items that violate the terms of your probation, or they believe you violated the condition of your probation. If referred to or successfully complete any PA 511 programming based upon eligibility, over the next 5 years, you shall perform 40 hours of community service. That community service must be documented, submitted to the probation agent over the course of your probationary term in written form. Finally, guideline range is 0 to 9 months. That means it's not a prison sentence. And the court, though it's been placed upon the court that they are to consider the guidelines. As I've stated before, we've had cases out there in other counties where the guideline range was followed, but it was overturned, despite the fact that it was within guideline range. Guideline range is 270 days in jail. That will be the sentence with credit for 1 day served. However, as it pertains to the 270 days, for the first 90 days of the sentence, you shall serve weekends. You will report to the jail Friday at 6 p.m., be released Monday morning at 6 a.m. The remaining jail time will be held in advance. Now, you are sentenced to 270, you are to serve the first 90 on the weekends. The reason the court is doing this is because there is a companion NA case, and most services are provided during the week. By doing so, that will give you the opportunity to continue with services to become a better parent. But there's also that negative side of the sting, that is the county jail time. Understand though, if you violate any of the terms and conditions of the probation, you come back
18 months to 5 years. That is the minimum Mr. Flory will serve before he is even eligible for parole review. And with multiple counts stacked on top of that, the picture is not a short one. Now, was this the right call? The defense argued that boot camp and probation would have done the same job. And honestly, for a first-time felony offender with substance use disorder, that argument isn't crazy. Courts do that every day. But here's what the defense couldn't overcome. A police officer was punched in the face. That officer bled. That officer had to be backed up by a sergeant with a taser just to control one man at a campground in Michigan, and in most states, assaulting a law enforcement officer carries a heavy weight at sentencing, and it should. But here's the bigger picture, the one that goes beyond Mr. Flory's case. Kratom is legal. It is sitting on a shelf near you right now. And as this judge made very clear, it is the new bath salt. The bath salt crisis of the early 2010s swept across this country before lawmakers could react. People were hurt, officers were hurt, and it took years and hundreds of cases like this one before regulations caught up. Are we watching history repeat itself? Because right now, in Huron County, Michigan, a judge is calling Kratom a poison from the bench, and nobody outside that courtroom is listening. If you found this case interesting, share it, because the next Mr. Flory might be in your county. I'll see you in the next one.